Hello and welcome to IFG Live. My name is Akash Pound and I am pleased to be chairing today's discussion at the Institute for Government, or the Virtual Institute for Government, A Nation Divided, What Does Scotland's Constitutional Future Hold? So thank you all for joining us. This is the week when the future of Scotland and its place in the Union has returned to the centre of the national conversation. On Monday, Nicola Sturgeon, First Minister of Scotland, speaking at SNP conference, promised to never give up on Scottish democracy and argued that momentum was on the side of those who favour independence for Scotland. And then on Tuesday and Wednesday, we had 2 days of hearings at the United Kingdom Supreme Court, where 5 justices of the court considered the question of whether the Scottish Parliament can hold an independence referendum. Scottish Government wants to do so next October, without the authorisation of the Westminster Parliament. And the court also spent quite a lot of time discussing a narrower procedural question, which is whether it is even legitimate for the court to answer this question at this point, given no legislation to hold a referendum has yet been passed by the Scottish Parliament. And we're going to explore both the sides of the court case, as well as wider questions about the possible future scenarios for Scotland. So today at the Institute for Government, we'll be discussing all these issues with an expert panel of 4 speakers who I am grateful for joining. So I'll now quickly introduce them and then we'll get the conversation started. So first, in alphabetical order, and I think first who we'll come to in the event, is Professor Aileen Mccog. Aileen is Professor of Public Law and Human Rights at Durham Law School, formerly of Strathclyde, Glasgow and Bristol universities. Aileen has written widely on UK and Scottish constitutional and administrative law. She also even got a name check, or one of her articles got a name check in the Supreme Court this week, which I think for an academic lawyer is a bit like scoring in the Champions League final or something like that. So congratulations. Second panelist that we'll be looking forward to hearing from is Jim Murphy. Jim was Member of Parliament for East Renfrewshire between 1997 and 2015. I think the constituency changed name, but for that region anyway, that area. Jim served in government under Tony Blair and Gordon Brown in various roles, including as Secretary of State for Scotland. He was then in shadow cabinet in a couple of positions and, quite briefly, leader of Scottish Labour. Jim is now Managing Director of Arden Strategies, the advisory firm. Third, welcome to Stephen Noon. Stephen was a senior policy advisor to First Minister of Scotland, Alex Salmond, for a few years, and he was also senior strategist for the Yes Scotland campaign in 2014 during the first, or so far only, independence referendum in Scotland. And Stephen is now studying, conducting postgrad research into devolution at the University of Edinburgh. And fourth, very pleased to be joined by Professor Adam Tompkins. Adam is now John Miller Chair of Public Law at Glasgow University. He returned to academia after spending 5 years as a member of the Scottish Parliament, representing the Glasgow region for the Scottish Conservative Party, and he was also, for I think much of that time, the party's spokesperson on constitutional affairs. So thank you to all 4 of you for being with us today. I'm really looking forward to your thoughts on these issues. So we're going to now kick off. I'm going to put a series of questions to our panelists, facilitate a bit of a conversation, and I'll also be very keen to involve members of the audience. So please do start submitting questions you might have for the panel as a whole or for any particular panelists using the Q&A function on Microsoft Teams, and then I'll put them to the panel on your behalf. Just a couple of quick housekeeping notes. So the Institute for Government is live tweeting this discussion from the account at IFG Events using the hashtag IFG Scotland, I believe. We're also recording this and as both in video and audio forms, the discussion will be uploaded to our website as a podcast and so on. So let's get started. And I would like to, first of all, come to Aileen. And if you may, Aileen, if you would, could you just first briefly explain to us and the audience in non-technical terms, albeit that some of it is quite technical, as we know, what were the questions that the court has been asked to consider?
Okay, well, I'll do my best to keep it non-technical. So as you said, there were two questions that the court had to decide. There's the question that the Lord Advocate actually referred to the court, which was whether the Scottish Parliament has the competence by itself, without the agreement of the UK government, to enact a bill authorising a second independence referendum. And that all turns on whether or not such a bill would relate to the reserved matter of the Union. So there was lots of discussion about, well, what exactly does relates to mean? The Scotland Act tells us in order to answer that question, we have to look at the purpose and the effect of the bill in question. So again, there was discussion around how exactly do you characterise the purpose of the bill, what kinds of effects are important, bearing in mind that this would be an advisory referendum, i.e. one which wouldn't have any necessary legal effects beyond the organisation and conduct of the vote itself. So that was the question that the Lord Advocate referred. But there was this second question about whether actually she was entitled to make the reference. And that question arose because this reference was made in an unusual way, relying on a pretty obscure provision in a schedule to the Scotland Act that's never been used before. So typically we would expect these kind of questions about the legality of devolved legislation to come to the courts in one of two ways. So either once a bill has been passed by the Parliament, there's a 4-week period before it goes to royal assent where one or other of the law officers can refer it direct to the Supreme Court. Or if that doesn't happen and it gets royal assent and becomes an act, then a range of people who have an interest can challenge it before the courts. But in this case, we're talking about a draft bill that hasn't even been introduced into the Parliament. The reason why it hasn't been introduced, though, is because the Lord Advocate has doubts about whether or not it's within the competence of the Parliament. If she cannot clearly advise the ministers in charge of the bill that it's within competence, then the minister can't introduce it into Parliament. So she was saying, well, yes, she recognises this is an unusual procedure, but if she can't refer it via this mechanism, there may be no other way of getting this important legal issue resolved by the courts, because there may never be a bill which can then be referred in the ordinary way.
Yeah. So essentially, she was asking the courts, please help me out, give me some guidance. Should I give this bill at the point when it might be introduced the green light, so to speak, advise the ministers that it can be passed by the Parliament?
Yeah.
Okay, great. Thanks, Aileen. That was terrifically clear and concise. Adam, I know you watched the hearings closely. I think you watched every minute of them. You said to me before we went live. So, I mean, what was your overall impression? Were you surprised by any of the arguments made in court, or by indeed the focus of the justices in their questioning?
No, I really wasn't. I think it was all entirely predictable. And the overwhelming focus on both days of argument, whether it was the Lord Advocate on her feet or the UK's lawyer, Sir James Eadie, on his feet, the dominant focus was this issue of process. The justices, quite notably, just sat back very politely and listened to the arguments about substance. The arguments about substance are the arguments that Aileen just referred to as being arguments about whether an independence referendum bill in Holyrood would relate to the reserved matter of the Union. Now that's a contestable issue. There are plausible arguments going both in favour of the view that such a bill would relate to reserved matters, and indeed that such a bill would not relate to reserved matters. It's a contestable issue, and it was notable that all 5 judges on the panel intervened not at all on any of either the Lord Advocate's or Sir James Eadie's submissions on that contestable point, which is look, only a fool would predict how the Supreme Court is going to decide a case judgment when the judgment's not yet been handed down. Much easier to predict how they're going to decide cases after you've read the judgment. And so I'm not making a prediction about what the Supreme Court will do, but all of the messages that you could glean from what it was that the justices were interested in the 2 days of oral hearings would indicate that they're going to decide this on process. And I don't think this means that we'll never get to the substance. It just means that we won't get to the substance yet. Because I think what will, if the court rules, and I put it no higher than that, if the court rules that this reference was made by the Lord Advocate prematurely, and that it was not an appropriate use of the Schedule 6 reference procedure, then that does not mean that Holyrood can't enact this legislation. It means that some hurdles have to be overcome before Holyrood can enact this legislation, but Holyrood can enact this legislation. So, for example, at the moment it's a government bill, but the government could hand it to a sympathetic backbench MSP, and then it becomes a member's bill. And then the Lord Advocate does not have to give legal advice on whether the bill would be within competence. That if there's a member of the Scottish Parliament that is clearly of the view that this bill would be within Holyrood's competence, then that member can introduce it, making the requisite certification of that legal intention without the Lord Advocate having to do anything at all. And then what will happen is that the legislation would proceed through its normal stages in the Holyrood process. It would doubtless be enacted because there is a pro-independence referendum majority in the Scottish Parliament. Indeed, there's a pro-independence majority in the Scottish Parliament. And at that point, after enactment, the ordinary Scotland Act procedures would no doubt kick into place, and the UK's law officers, namely the Advocate General for Scotland and the Attorney General, would refer the matter to the Supreme Court for a definitive ruling, which at that point the Supreme Court could not, as it were, wriggle out of on this substantive question of whether this legislation, having been enacted, does in fact relate to the reserved matter of the Union or not. That's from the outside perspective, that must just look completely baffling. If the Supreme Court knows that it's going to have to deal with this issue eventually anyway, why wouldn't it deal with it now? The answer to that is a really important answer, actually, in constitutional terms. The answer to that is we don't have a bill yet, and the Supreme Court exists to make rulings on what the law is. The Supreme Court does not exist to give advisory opinions about what the legal consequences would be were an unintroduced bill to be passed by the Scottish Parliament unamended in its current form. And that's the critical difference. And, yes, it's a difference of process, not a difference of substance, but so much of constitutional law is about process and not about substance, including this week's case.
Yeah, and is there, Aileen, I'll come to you in a sec. Just one follow-up. I mean, in terms of the potential ways that the decision could go, is there a kind of almost like a double rejection scenario whereby the court rejects the reference and so denies the case on procedural grounds, but also, I think in legal terms, in obiter, right, as a sort of aside, says, but if you do come back, it's quite clear to us that this would be denied on substantive grounds, which I think is what kind of happened with a previous case in the Scottish Court of Session, the Keatings case. Is that one scenario?
Kind of.
As well,
that's possible. Akash, that's possible. But whether the Supreme Court does say anything about that at this point or not, none of us knows. I mean, none of us knows what the Supreme Court's going to say, but all you can do is rely on what you've observed over the last couple of days. And what you've observed over the last couple of days are 5 justices in the Supreme Court very anxiously interrogating submissions on both sides about what the appropriate procedures are. And those same 5 justices very politely sitting back and listening without any intervention or interruption whatsoever on what are deeply contestable submissions about the substance of the issue, or whether such a bill would in fact, or would in law, relate to the reserved matter of the Union or not. And from that, one has to draw one's own conclusions. Yeah,
thanks. I mean, Jim, you're not a professor of law, but I think you've been following the case and the arguments closely, as have most people. So, I mean, what's been your observation of the way these different arguments have been made in the court and more widely in sort of public debate?
Yes, you are right, Akash. I'm not a constitutional lawyer, but I was involved in the passing of the original legislation back in 1998, when, as a newly elected member of Parliament, we introduced the Scotland Bill that became the Scotland Act, which then established the devolved Parliament. I'm surprised by the entire process. I'm surprised we've got this far in the process. I'm not disputing people's rights to take this process, but I'm surprised because the Supreme Court has been asked to rule on a piece of legislation that hasn't even been introduced into the Scottish Parliament, on an issue which Scotland's Lord Advocate is unwilling to certify as lawful, and is reduced to arguing that they want a consultative referendum with zero legal impact. I'm also surprised that the SNP then, to some extent, bigfooted their own law officer by making their own submission to the Supreme Court. And finally, I'm just bamboozled that the argument that a referendum on splitting up the United Kingdom doesn't relate to the United Kingdom. I think it's legally ingenious in the way it's being argued, but I'm not convinced, because the test in the Scotland Act, and I think it's in Schedule 5 of the Scotland Act, is, does the matter relate to a reserved matter? And on the basis that the union of the Crown, the union of the kingdoms of Scotland and England, and issues relating to the Parliament of the United Kingdom are reserved to the UK Parliament, I think by any reasonable test, this then relates to a reserved matter. And on that basis, I'm surprised we've come this far.
Yeah. Well, yeah, you're right. I mean, the test is whether it relates to any reserved matter such as the Union in terms of its purpose and its effect. And a lot of the argument on the substantive side has been, well, what is the purpose? I mean, the Scottish Government case, as I understand it, is that the purpose of a referendum would simply be to ascertain the views of the Scottish people. And indeed, that's, you know, on the face of the bill. The UK government, I think, in line with what you were saying, argue it's sort of self-evident. That's the way that the lawyer put it for them, that the purpose ultimately is of course to secure independence. So the bill should be blocked for those reasons. Glad to see Aileen's back. Stephen, did you want to come in on this? Because I mean, Jim's just been commenting on the Scottish Government strategy of trying to bring this case to the court before passing a bill, making these arguments in perhaps well, creative ways. I mean, what do you think of the Scottish Government strategy?
I'd be interested to hear what Aileen and Adam have to say on this reflection. But the more constitutional this case is, the more chance the Scottish Government has of winning. I mean, that seems to be the message from the SNP's submission. If the Supreme Court, UK Supreme Court, treats this case in a similar way to the Canadian Supreme Court, the Quebec secession referendum, you begin to open and bring in wider constitutional principles which might support the Scottish Government case. So perhaps doing it this way, bringing it in before the legislation has been produced, serves to constitutionalise the issue, takes it away from the ordinary interpretation of legislation that might be the norm, and begins to allow arguments to be made around, okay, well, what is the route for this decision to be taken? I mean, there's a fundamental constitutional question here. nationalist, unionist. I think we've worked on the basis that the UK is a union state. It's a union by consent. And if the judges say that the Scottish Parliament doesn't have the legal capacity to hold a referendum, what then becomes the route for Scotland to express that consent? So that is a strong constitutional / political argument. It's a sort of argument that I think would appeal more to a Canadian-style Supreme Court, but in a sense that is perhaps the best card for constitutional political reasons for the Scottish Government SNP to play.
Yeah, thanks. And so Aileen, yeah, glad you've rejoined us. On the question of the SNP's separate submission. So to be clear to those who haven't followed so closely, there were the two governments made their submissions. The two governments were then represented in court, but separately the SNP made a written submission to the court, making a slightly, actually quite a different argument to the Scottish Government, the SNP as a party, on why, in its view, a referendum should be allowed to happen, and they appealed to the idea of national self-determination and democratic principle. Do you want to say anything about that intervention and whether you think that's likely to carry any weight at all?
Yeah, thanks. Can you hear me now?
Yes, thanks.
I don't know what happened earlier. Yeah, I mean, I think the points that Stephen has been making, I think, probably illustrate some of the limitations of constitutional adjudication in our type of only partially codified constitution, and we saw the same kind of limitations in the first Miller case, where the court can take account of some aspects of the constitution to the extent that these are legalized, but the kind of broader political aspects of the constitution rarely get a look in. So the SNP's submission, I thought, was quite interesting in that they'd worked quite hard to show why these broader questions of self-determination could be relevant to the determination of the legal question. So they were arguing that these were principles that should be taken into account in the interpretation of the Scotland Act. So no kind of freestanding reliance on a right to self-determination or anything like that. It's just about trying to get these into the interpretation of the Scotland Act. Now that was the kind of strength of their submission. The weakness of their submission, though, is that in having to make those broader principles legally relevant, you narrow the reliance that can be made on them. So the right to self-determination in international law, for instance, almost certainly does not apply in this situation. If we follow the Supreme Court of Canada in its Quebec secession reference, they drew a very clear distinction between the right to internal self-determination and the right to external self-determination, external self-determination being the right to secede, and said quite clearly that a people that has a high degree of internal self-determination doesn't also get the right to external self-determination. External self-determination is only for those genuinely oppressed minority groups that have no internal self-determination. So I think that was the problem there. I think those arguments, therefore, are unlikely to play much role in the Supreme Court's reasoning. I think what will be more interesting is whether they say anything at all about them or just kind of pretend they didn't happen. I mean, they could say problematic things about those arguments. So from the SNP's point of view, it might be better if nothing is said on those broader points.
Okay, thanks. Stephen and Adam both want to come in on that point. Stephen, you first.
So maybe again, the question I would have for the legal experts is, the Canadian case obviously put duties on both the Quebec and the Canadian governments to engage in a certain way if there was a democratic expression towards secession. Is there a chance that the court could express a responsibility on the behalf of the two governments to engage in this, to actually find a legal path forward?
I mean, if I come back on that, I would have said absolutely not. I think they will avoid that kind of broad constitutional but political intervention as far as possible. They will stick to the technical legal issues, and Lord Reid made that quite clear at the beginning of the hearing on Tuesday.
Yeah, he seemed to do so. Adam.
Yeah, I completely agree with Aileen about all of that as it happens. I think that the entire thrust of the Supreme Court's case law on the law of devolution as it relates to not only Scotland but also Wales, and even mainly also to Northern Ireland, is to avoid all of these broader questions of what you might call fundamental constitutional principle, and to focus with the sort of forensic discipline that we saw yesterday in his submissions by Sir James Eadie on the minutiae of what the legislation enacts. And that gets me back to something that Jim Murphy said, which I just wanted to come back to, because Jim expressed what a lot of people expressed to me, which is just puzzlement as to how it could even be plausibly arguable that a referendum about ending the union does not somehow in legal terms relate to the union. So can I just say something, Akash, about
yes,
how
please.
it can be plausibly argued that an independence referendum does not relate to the union, and that therefore an independence referendum bill could plausibly be passed by the Holyrood Parliament without Westminster's consent. And the key to this lies in those two terms that Aileen talked about in her first contribution, which are the terms purpose and effect. So whether a provision of Holyrood legislation relates to a reserved matter, such as the union, depends, as Aileen correctly said, on the purpose of that legislation having regard, amongst other matters, to its effect in all the circumstances. So you could say that the purpose of an independence referendum is not to terminate the union. The purpose of an independence referendum, the legal purpose of an independence referendum, is simply to ask the people of Scotland their view about whether the Scottish government should pursue negotiations with the United Kingdom about the severing of the union. So if the purpose of the bill, if the legal purpose, we know what the political purpose of the SNP is, but the political purpose of the SNP is distinguishable in law from the legal purpose of the legislation. And if the legal purpose of the legislation is, this is a big if, this is a big if the legal purpose of the legislation is simply to consult the people of Scotland, well, consulting the people of Scotland is not a reserved matter. So the purpose of the legislation could be held to be within competence. Then you go to its effect. What are its effects in all the circumstances? And this is where the Lord Advocate's submissions were really quite striking, because she said in terms that the legal effects of even a yes vote in an independence referendum are, quote, nil, unquote. There are no legal effects. There are no legal effects to a yes vote in a referendum. A yes vote will not deliver independence. These aren't my words. These are the Lord Advocate's words. The Lord Advocate herself was arguing that even a yes vote in a referendum will not deliver independence. Independence can be delivered in law only by enactment passed by Westminster. Right, it can't be delivered by Holyrood, and so if you define the purpose and the effect of an independence referendum in those admittedly rather arcane and narrow terms, then that's how you could run the argument, plausibly, I think, run the argument that as a matter of law, a bill paving the way for an independence referendum does not relate to the reserved matter of the union. Now, if that argument is ever to be successful in the Supreme Court, it will have significant political consequences, because what that argument will do is so hollow out the meaning of a referendum that those who don't want to take part in it can simply boycott it, right? So what Holyrood clearly doesn't have the legislative competence to do is to enact without Westminster's consent an independence referendum that looks or sounds or feels like the 2014 independence referendum, in my view. And I think Aileen and I may disagree about this, but in my view, a referendum, because the 2014 referendum was understood by both sides to be determinative of the matter, right? If Scotland voted yes in 2014, Scotland would have become an independent state, independent of the UK. Now, I think it's difficult to argue that such a referendum doesn't relate to the Union. But if you so define the purpose and effect of an independence referendum so that its purpose is simply to consult the people of Scotland and its effect in law is nil, then it can safely be boycotted by people like me and I think people like Jim who want to have nothing to do with this project.
Well, can I pick up on
well,
that?
yeah, so 2020, yeah, absolutely, Jim. Just to comment on what Adam was saying. So yeah, in 2014, of course, technically, legally speaking, the referendum also had no automatic legal effect. However, it was based on a political agreement, the Edinburgh Agreement between the two governments, which included an explicit commitment on both sides to respect and act upon the result. So yeah, but as you say, without that, it might be easy to boycott. Yeah, Jim, I'll bring you in now, and then Aileen, I'll come to you.
Yeah, just quickly on the constitutional argument, again with the health warning that neither Stephen and I are qualified constitutional lawyers, is that certainly from reading it, from reading the Act, reflecting on the passage of the Act as I did back all those years ago, and some of the Supreme Court's subsequent cases that it's adjudicated on, it seems to be that whether an issue relates to a reserved matter to the UK Parliament, as whether it's the competence of the UK Parliament, is the overarching test. And the tests on purpose and effect are ancillary tests. And again, that'll be interesting to see how the Supreme Court adjudicates on that constitutional issue as to the hierarchy of tests. But certainly my reading is relates to has the senior status on those tests. But to come to two other points, which are slightly less, or significantly less about the Constitution and more about the politics. First of all, referendums don't have a legal effect in the UK. The Brexit referendum had no legal effect. The UK Parliament could have chosen simply to have ignored it. I mean, I had the great misfortune, or great fortune perhaps, one of the other roles I had in government, I was the Minister for Europe that introduced the Lisbon Treaty into UK law, which then introduced the ability to, that treaty allowed countries to then leave the Union of Europe. But nevertheless, having a referendum didn't have legal effect. So I think my overarching view of this is that the Scottish government has asked the most senior court in the land to adjudicate on an issue that is just intensely political and about political rather than legal judgments. I accept admissibility is a legal test. I accept that relates to is a legal test, but the Scottish government itself has been unable to resolve whether any of these matters are legal under the terms of the 1998 Act. And perhaps anticipating a legal challenge from a private citizen, admittedly probably a well-funded private citizen here in Scotland, they've taken this route instead.
Yeah. Okay. I want to move on to the politics. You started talking about that, and we've got some questions coming in from the audience too. Aileen, I think you had another, maybe just a final quick comment on this part of the conversation.
Yeah, so two things. One, I mean, Jim is right, of course, that this is a highly political issue, but you know, just because it's a political issue doesn't mean to say that there aren't legal questions to be resolved, and there clearly are legal questions to be resolved. So it doesn't make it inappropriate to refer those to the Supreme Court. I mean, the Lord Advocate, I think, made quite a powerful argument that the alternative is that she is the final arbiter of the legality of an independence referendum, which is constitutionally highly problematic. But I wanted to pick up on what Adam said about the Lord Advocate having to argue against the significance of the referendum to make her legal case. But of course, that could be said of the Advocate General as well, because he has had to stress the political significance of a unilateral referendum in order to make his case. If he loses, you have a load of rhetoric in his written submissions about how politically important the result of a referendum would be. So yeah, you know, unionists can continue to choose to boycott it if they want, but they'd be doing that in the face of the UK government's law officers contradicting it and saying how politically important it would be. So that's all I wanted to say.
Very interesting point. Thanks. I want to move on to kind of what happens next. We've explored the issues at the heart of the case and some of the different scenarios in terms of the decision that the court might reach. But yeah, but what happens next? So I want to start by coming to you, Stephen, and asking if the Scottish government wins the case and says yes, we can take the reference, and yes, a referendum can be held. The arguments that Adam set out have persuaded us. Not that Adam necessarily believes those arguments, but the ones he put out as the way that this case can be argued. What happens next? Are we definitely heading then for October 2023 referendum? Is that feasible? You were around last time when it took a lot longer to sort of move from agreement on that a referendum would take place to actually holding a referendum in 2014. What do you think?
Well, I mean, the First Minister has said that that's her hope and intention. I think there are questions around the timetable. I think that that's not a bad thing in itself. I think if the Scottish Government got a yes to the referendum, that would be good enough. That would make them happy enough. And if the referendum itself was held a little bit later, I think they'd be perfectly relaxed about that. I mean, my advice to them would be to actually, give us some time to do this referendum in a way which is as constructive and unifying as possible. And that requires, I think, the referendum to come after a conversation. We will talk a wee bit more about what that conversation can be like. But for me, as a supporter of independence, it's not just essential that we become independent, but also essential that we become independent in the best possible way. And that's the way that unifies the country, pulls together 55%, 60% of people to get a yes vote. And part of that is the style of the campaign. The First Minister's language at the weekend and her speech around a campaign of respect, compassion, love, I think has the capacity to increase the yes support, but much better, in my view, would be some sort of process leading up to the referendum where a genuine cross-party Civic Scotland national conversation can take place.
Mm-hmm. Thanks. Adam, I think you wanted to come in. I was also going to ask you, so I'll put this to you at the same time. In that scenario where the Scottish government wins, do you think it's likely the UK government would simply legislate at Westminster to block any referendum happening?
Only if they're completely insane, which they might be. I think that would be a tactic or a strategy which would succeed only in accelerating Scotland's divorce from the rest of the United Kingdom. So I wouldn't put it past Truss and her advisors to think that was a good idea, because I think Truss and her advisors are very badly mistaken about what unionist strategy should be. But I wanted to speak in support of a number of things which I think are animating Stephen's contribution to this conversation, and indeed Stephen's contribution to the Scottish public conversation since his return to Edinburgh a few weeks ago. It's great to have you back, Stephen, because you're making some significant interventions in the conversation, which I think are long overdue and very welcome, if I can say so without destroying your credibility amongst your erstwhile supporters. And that is because, look, this is a really serious point. Scotland is a divided country. It is a tribally divided country. And those tribal divisions are not between left and right. They're not between leave and remain in Brexit terms. They're between yes and no. Yes and no is the fundamental dividing line in Scottish politics, and has been since about 2011 or 2012, for at least a decade. And the problem with that is that all sorts of other things which need to happen in Scotland are not happening because the tribally divided nature of our politics is somehow preventing them from happening. Now, I want my kids to grow up in a Scotland which is more prosperous, with better schools, with better infrastructure. But Scottish prosperity is being held back. Whatever your view about growth and Trussonomics and all the rest of it, Scottish prosperity is being held back at the moment because of our constitutional obsession. The reform that is needed to Scottish schools to improve them, and they are in sore need of improvement, is being held back because of our tribal constitutional politics. And the investment that we need in our infrastructure is being held back for the same reason. My most depressing day as an MSP was a debate about drug deaths. Scotland, and in particular Glasgow, the region I represented in the Scottish Parliament, has an appalling problem with drug deaths, a problem as grave as, or graver than, any other country in Europe. It is Scotland's national shame. And even a debate about drug deaths got hijacked by what I am going to call the goddamn Constitution, because it became clear to some MSPs that one aspect of a potential solution to the drug deaths problem, namely safe consumption facilities, was reserved under the Misuse of Drugs Act, and that therefore was Westminster's fault rather than Holyrood's fault. And the debate that should have had absolutely nothing whatever to do with the Constitution got hijacked by that. So here's an example of a really important matter of social policy that Jim in the Labour Party and Stephen in the SNP and me in the Conservative Party, just about still in the Conservative Party, ought to be able to agree on, but which the Constitution got in the way of. And I am desperate for a Scottish politics that moves beyond that tribal division. And I do not think that that is going to be possible while we still think about independence as something which can be delivered only in a 51-49 referendum. Right, because it is the politics of the referendum that has divided Scottish society. And one of the things that I think, I don't want to put words in his mouth, and if I'm mistaken about this, Stephen, please correct me, but one of the things I think Stephen has said is that we should begin to think about how we can move forward in our Scottish political conversation without thinking about it in the binary terms of a referendum.
I think, yeah, I mean, Stephen, you've used it, thanks, Adam, you've used the phrase de-escalation of the constitutional conflict, and certainly advocated moving towards compromise. So yeah, I'll please do come back and say a bit more about that. Jim, you wanted to come in.
I think that and so we're talking more about the politics now, but for elements within the SNP, it's like the old phrase about to a hammer every problem is a nail, and no matter what the issue, the SNP are the hammer, and no matter what the issue, no matter how complicated or how tangential, it is the nail of independence. And so that frustrates, and I'm sure there are people on the other side who take as partisan a view. I hear less of them because, bluntly, under a Conservative government, it's quite hard. This Conservative government, it's quite hard to make an argument that the union in and of itself is the means to social justice. Whereas we hear that often about the case for independence. I think what worries me, though, to be reflective, is that if the court does say that it's within the power of the Scottish Parliament, and I don't want to tempt us into an additional conversation, but it does throw up tests about the Welsh government, the Welsh Parliament, the Northern Ireland Assembly. We have obviously Sinn Féin as the largest party. We're possibly going to have another election there. If the issues of the future of the union are no longer the primary, the powers are no longer primarily held or adjudicated to be exclusively held in the UK Parliament, that opens up a whole series of precedents in other parts of the United Kingdom, possibly in terms of the politics and independence and other movements. The last thing I'd say is that for those who, I'm not a unionist, incidentally, I believe in the union, but I'm not a unionist, I'm a devolutionist. Right? So and devolution and independence are opposites. One's not a path to the other. But for those of us who are devolutionists, partisanly, it would suit if Nicola Sturgeon stuck to her October 23 timetable, because it's a crazy timetable. I mean, it's undeliverable, but that's neither here nor there. But in a country where only 1 in 3 people actually want a referendum at the moment, it would be completely tonally out of keeping with where Scotland is. And the final point, I think whenever this referendum takes place, 2 things have to happen. If there is ever another referendum, those of us who are on the devolution side of the argument have to hear that this is the last one. I mean, or do we just do the day after and assume that independence doesn't win through? Does the campaign against that for a 3rd and then a 4th referendum? Because at some point this has to be resolved. And the final point is that in the absence of absolute legal clarity, if it has no legal effect, what's to stop the sort of dyed-in-the-wool unionists and passionate devolutionists just to opt out of it? In the same way that in 1970, so for the last thing I'd say is that for those of you who don't follow it, 1973, Northern Ireland had a referendum.
Yeah.
The nationalist SDLP and the Republican Sinn Féin urged their supporters not to participate. It had a 98% outcome, but in a very low turnout.
Yeah.
We don't want any repeat of that in Scotland.
Yeah. Well, Adam has already, I think, raised the possibility of that kind of boycott, albeit that Aileen raised the counter argument against that. I want to bring in some questions from the audience. So we have a few, and please do submit some more if people have burning questions for our panel. Stephen, there's one that I want to put to you because you're named in by the anonymous questioner. Question runs as follows. If the Scottish government loses the case, we've just been talking about the other scenario, how do the panel see Sturgeon's plan to turn the next general election into a de facto referendum playing out? And also, do you think she was actually paving the way for ditching this strategy this week in the conference speech when she didn't actually use those exact words? Stephen, yeah, what's your take on that?
I go back to the same starting principle. We are better moving forward in a way which gets us to 55–60%, an identification of the settled will of the Scottish people. And my concern around the plebiscite election approach is that it doesn't move us into that territory. It continues us in the path of 2 groups at 50–50 each, not really talking to each other, but talking past each other. This is an issue that is not going to go away. And so I think we have to, look at serious ways of addressing it. I mean, I spoke about the Canadian court and how they sort of pointed towards how the politicians should respond in a case. And I think we need something which points us in the direction of how politicians should respond. In the Quebec case, it was a responsibility for politicians to negotiate. And so for me, we move forward in Scotland's constitutional journey through conversation, through both sides coming together and having a conversation. And that includes issues like, if you have a referendum at some stage, what does that mean for future referendums? So absolutely, there are rights on the side of the pro-UK side, not to have this as being a never-rendum. So we have to have a conversation which recognises the rights and interests of both sides and draws on those to come to a solution which can command the support of a significant majority of people in Scotland. So let's find out what the settled will of Scotland is, as we did in the 1990s. And in order to do that, we have to have a conversation. We have to have a mechanism put in place where Labour politicians, SNP politicians, Conservative politicians, UK and Scottish politicians are willing to sit down and talk about what sort of relationship do we want to have in the future. For me, I mean, I disagree with Jim that devolution and independence are opposites. I think they are different, but they are different in terms of shades. For me, I was happy to back devolution because it was about giving Scotland more independence over areas like the health service. And I think we can have more independence in other areas as well. So for me, the question is, how independent do we want to be? and how much of a relationship do we want to have with the rest of the UK. And I think we can find a place when we're asking those questions that has support of not 50-50, but 60%, 65%, as we had back in the 1990s.
Thanks. Okay, another question from Michael. Aileen, I might come first to you on this one. So Michael says, I'm a Scot born in Edinburgh. Have always lived in the UK, first in Scotland, but now in England. Why don't I get a vote in any referendum about whether Scotland should stay in the UK? Well, we know why in legal terms, but I guess there's an interesting question of principle there. I mean, you now work in Durham. I think maybe you're still resident in Scotland, so I'm not sure whether this is the situation you find yourselves in. But yeah, I mean, if in the event that a referendum takes place, what's your view on the franchise, the related questions about identity and who should be part of this decision?
Yeah, I mean, this is a question that comes up quite often, and you're right. I do work in Durham, but I still live in Scotland. But in 1997, at the time of the devolution referendum, I was living in Bristol and didn't have a vote, despite being passionately interested, because I was a passionate devolutionist, and I still am very strongly in favour of devolution. I think that the difficulty for any sort of expat vote it comes down to questions of definition. What degree of connection do you have to have with Scotland? How long ago did you have to be born there? Did you have to grow up there? How long ago did you leave? What if your parents are Scottish? It becomes very, very difficult. And those kind of questions around the franchise in any referendum are flashpoints, points where accusations of gerrymandering can be made. So the safest option in any referendum is to stick to the closest existing franchise that you have. Actually, in 2014, for that reason, I was opposed to extending the vote to 16 and 17-year-olds because I thought it did have that air of gerrymandering about it. I mean, obviously there's principled support for it, and the franchise has been extended to 16 and 17-year-olds more generally. But I think whatever you do, you want to try and avoid that perception that you are gerrymandering the franchise. So the best one to use, I think, is the one that we use for most elections in Scotland, which is the Scottish Parliament franchise.
Which is, yeah, so as you say, has in recent years been broadened to include 16, 17-year-olds.
And it's based on residents.
People from anywhere across the world who's resident in Scotland, as I understand it. Yeah.
And I think that's a perfectly justifiable, franchise in principle as well. I don't think franchises have to be linked to citizenship or birth, or there's an appeal in principle to having a franchise which is based on residence. Yeah. One could link it, I think, to concepts of civic rather than ethnic nationalism and that kind of thing. Yeah. Interesting. Okay. Another question from Phil in the audience. Adam, I might go to you on this one first, if you don't mind. So the question is, a lot of the SNP's rhetoric focuses on the idea that Conservatives in Westminster don't represent Scotland. So I'm not sure how many Scottish Conservative MPs there are at the moment, but it's just a handful. Does the panel think that reflects the fact, so is this basically to do with the electoral system, first past the post, which means that there are very, very few MPs of any party other than the SNP actually representing Scotland, just because of the very disproportionate nature of the results? So I guess the question really there is, does our electoral system make these tensions worse and lead to this the maybe unstable nature of the union?
Of course it does. I mean, somewhere between a fifth and a quarter of the Scottish electorate vote for Conservative candidates, or have voted for the Conservative candidates in the last 10 years. It's about the same for the Scottish Labour Party these days, which is a bit lower than it was in the 30 or 40 years before that, and it's about double that for the SNP. So in terms of votes cast, the SNP get approaching half the votes, and almost all of the rest are more or less evenly split between the Labour Party and the Conservatives, and then the Greens and the Lib Dems pick up a few here and there, but not very many. I think that it would be better for us all, not just better for Scotland, but better for us all if we had electoral systems for all levels of government that represented that reflected the proportion of votes cast. I'm in favour of electoral reform for the House of Commons, not least because I think we would get better government if we had a government that knew and understood that when it made, for example, policy on the hoof with regard to fiscal matters, that it wouldn't be able to get that policy through unless it could obtain parliamentary support. And obtaining parliamentary support in a system that relied on cross-party and inter-party conversations of the sort that Stephen is talking about, rather than on antediluvian whipping operations, would make for a much healthier government. But that's a conversation which is not really a conversation about Scotland's place in the Union, or indeed Scotland's place out of the Union. That's a conversation which is about the relationship between votes cast and seats won, which is a UK-wide problem, I think, at the moment, in terms of the way in which the House of Commons is run, badly run and mismanaged.
But it's also more than that, Adam. Just quickly, I'm a recent convert to PR, simply for different reasons, which is that both the Labour Party, for a short period under Corbyn, proved its. So I believe in coalition government. Right? That's just my starting point. That's what I believe in. I happen to believe that both the Labour Party and the Conservative Party have been coalitions, and therefore by voting for one of those parties, you got a coalition. But under Corbyn, Labour stopped being a coalition, and under Johnson and Truss, the Conservatives aren't currently a coalition. So I happen to believe that it's a constitutional argument for a different purpose, not about the weights of votes, but plurality of thought within the way in which we are governed. And both parties, both main parties, I don't know enough about the SNP, but both main parties have let themselves down in that regard, and therefore the public should have that protection.
Okay, thank you, Jim. Okay, we are pretty much coming to the end of our hour together. It's been a fascinating conversation. So I think we will probably draw it to a close there. I just wanted to say thank you very much to our four panelists. I've really enjoyed the conversation, learned a lot, feel like I've been in a high-level legal seminar for part of it, which is good, having not personally studied law myself. So thank you for that part of it and for all your other insights. Thanks to everyone who's tuned in and submitted questions. Sorry, I didn't quite get to ask all of them. And also just wanted to say more of a personal thanks to Penny Cranford, who's our events producer, who's worked on all our devolution events for the past few years and done a great job, and is about to move on from the Institute for Government, but she's really made this event happen. So thank you to her. And please do tune in for future Institute for Government events. I think we've got one coming up in a week or so on what works in government, featuring David Halpin, the government's What Works advisor. Then we have an event after that on the public appointments process, and lots more after that. So that's all from me, and thank you very much for joining. Bye-bye.